Yes, Mr. Charlotte.
Thank you very much, my lady. Good morning, my ladies and my lord. I'm going to begin by picking up on my Lord Justice Warby's question that came at the end of yesterday's session. Just to add a couple of comments on that. Then going to go into the law on the threshold of seriousness before addressing Jamil abuse of process and what is actionable damage, very briefly, repetition issues. Going to end with submissions on why all the individual claims should be struck out. I will do this first by reference to generic facts that apply to every single case, and we say make every single claim for damage completely unreal. The court needs further persuasion. I will take the court to a small, emphasis the word small, number of particulars, bearing in mind that the court has clearly indicated that it does not want to be addressed at length on such particulars. Now, the agreed timetable has my submissions going the whole morning and 15 minutes of the afternoon session. I'm confident with a fair wind, given that it's clear that as a result of the court's extensive pre-reading, it's on top of both the facts and the law, that I should be done by 12. My learned friend has an hour in reply if he needs it, so we should be done by lunchtime. So I hope that that's some reassurance to the court.
Thank you very much indeed.
And thank you very much, my lady. So without further ado, picking up on my Lord's question about where these cases were on the spectrum of objectively reasonable, well-founded fears or fears that are baseless, we say, I said yesterday, that these claims are all at the extreme end of entirely baseless and entirely hypothetical. Now, obviously, on relation to this, the generic facts are irrelevant, but what the appellants knew of the generic facts at the relevant time are relevant. Right from the very outset, the appellants have always known at the very least what information their ABSs contained. They get them every year. There's no health information, no financial details capable of leading to ID theft and so forth, no bank details, no medical information. They also will have known it was sent to their name in an opaque envelope marked private and confidential, as was the norm. Before they would even have realised anything had gone wrong, a significant number of the appellants would have received their ABS by way of it being returned to them. On notification from the force, which came quickly, the appellants also knew at that point that the ABS had gone to one known address, which had previously been given by them as somewhere to which the ABS should be sent. This was very often parents or family members' house. So at every stage, we knew, given what they knew, any fears, and that's the sole basis for the claim of distress, were completely unfounded. In other words, it was unreal to say any such fears genuinely arose, and the contemporaneous lack of complaints, lack of taking out CFAS protection, betrays the true position. They may have been frustrated, a word that's used throughout the individual particulars rather tellingly, but they simply cannot have been genuinely distressed. And frankly, it would be worrying if police officers to view the misposting as a hugely distressing, catastrophic event. It is something we all experience in our day-to-day lives. So that is what I want to add in response to my Lord's question. Turning now to the threshold of seriousness. My ladies and my lord, looking at the written submissions on this issue, it would appear that this was perhaps the legal issue most in dispute between the parties. In particular, both the appellants and the ICO in their written submissions contend no threshold of seriousness should be applied in damages claims under the GDPR, Data Protection Act 2018. Now, whilst there is clearly a difference of approach between the respondent's case on the one hand and the appellant's and the ICO's case on the other, the difference is perhaps not as large as it might initially appear. In particular, the appellants do not suggest that a number of cases relied upon by the respondent on the threshold of seriousness issue, for example, Rolfe and Driver, which we're going to come to shortly, were wrongly decided, but merely they were first instance judgments that don't establish any general principle. Take that from paragraph 112 of the appellant's skeleton, which is at CB 116. The ICO, in his written submission to the 21st of May 2025, goes further and endorses the court's decision in Rolfe, we're going to look at shortly, to dispose of the claim summarily. Now, whilst the court in Rolfe based its conclusion that the claim should be summarily dismissed squarely on the application of the threshold of seriousness, the ICO, at paragraph 10 of their written submissions, suggests that the same conclusion could, and indeed should have been reached, without the application of a threshold of seriousness being applied, on the basis that, in essence, what the court did was reject the asserted level of non-material damage and conclude no recoverable damage had been suffered on the facts. There was accordingly nothing to compensate. So, my ladies and my lord, even if you reject our submissions on the existence of a threshold of seriousness de minimis test, it remains the case that there must be, and has always needed to be in the Data Protection Act, a tenable basis for a claim for damages. We say that, given the facts which apply to every single case, as highlighted by the Information Commissioner itself in October 2019, which I took you to yesterday, suffering any recoverable damage at all is completely unreal, to use the language of Mr. Justice Nicklin in relation to some of the 14 cases where they had been opened. Now, the strikeout application was formulated on the basis of a threshold of seriousness because in its reply, the appellant did not take issue with the respondent's argument that a threshold of seriousness applied to both the misuse and the data protection claims, and therefore that was a thought appropriate way to frame our application. Of course, they did take issue with whether the threshold applied to the particular cases, but the general principle was not disputed in the reply. Our case has been clear in any event. Essentially, there is no real damage here. It's important to bear in mind we are not saying that the threshold of seriousness should apply to all remedies available under the DPA, GDPR. There's always the option of complaining to the ICO. We are, however, saying that the threshold should apply, as it does to all similar information law causes of action, to a claim of damages, which is the only remedy being sought by the appellant. Now, my submissions on the threshold of seriousness are going to have three parts. Firstly, I'm going to consider the domestic authorities. Secondly, I'm going to consider the European authorities, bearing in mind, of course, it's common ground that all the relevant decisions post-date IP completion day, and therefore the court is not bound by them, but may, if it chooses to have regard to them. And thirdly, address the matter, the issue as a matter of principle. So that's the broad structure. So first, the domestic authorities, and I'm going to start with Lloyd and Google, which you have at tab 25 of the authorities bundle, begins on page 576. And I want to take you to paragraph 153, which is on page 627.
Sorry, paragraph?
153, top of page 627, my lady. Now, you looked at this yesterday. I'm sure you're familiar with this passage. It's contended by the appellants and the Information Commissioner that this is just mere dicta because it wasn't an issue in contention. I accept that the claimant accepted there was a threshold of seriousness. This obviously isn't the first time a domestic court has concluded a threshold of seriousness applied. The judgment of first instance, the judgment of Lord Justice Warby, similarly concluded that the threshold of seriousness applied to the 1998 Act. But we say the court is not just noting what the claimant says, it's accepting that what the claimant says is correct, and it's then applying it to the particular case. On the claimant's own case, threshold of seriousness applied to a breach of DPA, give rise to compensation under section 13. I cannot see that the facts which the claimant aims to prove in each case are sufficient to surmount this threshold. If, contrary to the conclusion I've reached, those facts disclose damage within the meaning of section 13 at all, I think it's impossible to characterise such damage as more than trivial. So the alternative basis that the Supreme Court were determining in this case is, one, there's no damage, that was a primary decision, but if we're wrong on that, and we obviously don't think we are, it does not get over the threshold of seriousness. Now, the Supreme Court doesn't include passages like that in their judgments sort of without thinking about it carefully. If the Supreme Court was in any doubt about the applicability of a threshold of seriousness in this context, it would have referred to that doubt and said, well, we haven't heard argument on it, we'll consider it in a future case, preliminary views are this, but that's not what they've done. They said, we think there is a threshold of seriousness, and applying it to this case, the claimant doesn't get over it, and that is our second reason why this claim fails. So we say, in relation to the 1998 Act, so I quite accept this is limited to the 1998 Act, that this is binding authority that a threshold of seriousness applies. Clearly from this passage, the court was considering the issue of whether damage as opposed to breach was trivial, because it uses the words impossible to characterise such damage as more than trivial. And it's the claim for damages which leads to significant use of court time and resources, as well as generating costs. The same considerations apply in the DPA field as do apply in defamation and privacy, the need for individualised assessment, which is one of the points the court concluded in Lloyd and Google. So we say there is binding authority in relation to the 1998 Act. There is no binding authority on the GDPR, we accept that. But if the court is going to adopt a different approach, it needs a good reason to distinguish the Supreme Court's approach under the previous legislative regime. And we'll come to that issue when I discuss the issues of principle. But we say there are no good grounds for adopting a different approach, distinguishing the Supreme Court's approach in Lloyd and Google. Paragraph 19 of our skeleton, which is core bundle page 135, we address a number of cases where the threshold of seriousness has been applied by the High Court under the GDPR, and I wanted to take you to those cases now, my lady and my lord. The first is the Rolfe case, Rolfe against Veal, Wasborough, Vizard LLP, which is at tab 24, beginning at page 563. Now, this case concerned an email. The defendant emailed a letter before claim in relation to unpaid school fees to the wrong person, who immediately confirmed that it had been deleted. Notwithstanding this, a claim was subsequently issued for damages under Article 82 of the GDPR and Section 169 of the Data Protection Act 2018. And the personal data in this case, we say, was more sensitive. There's a demand for payment and an embarrassing allegation that the individual in question has failed to pay school fees. That was the basis of the claim. And the court addresses this at paragraph 9. where the court said it was said by the solicitors to the claimants, but not in the form of statement from the claimants directly, that they had lost sleep worrying about possible consequences of the data breach and that it made them feel ill, extensive time spent dealing with the issue. This was all a factual dispute and a trial was required, reasonable prospects in showing that loss and damage crossed the de minimis threshold, which is a factual issue for trial. Much of the alleged distress stemmed here from the fear of the unknown. It was said by the parents in terms that the recipient might have been given. So, strong analogies with the present case. And paragraphs 12 and 13, the court sets out its reasoning. It says, what harm has been done arguably? We have a case of minimally significant information, nothing especially personal, such as bank details or medical matters. Rapid set of steps taken to ask the incorrect recipient to delete it, which she confirmed. No evidence of further transmission or any consequent misuse. It'd be hard to imagine what significant misuse could result given the minimally private nature of the data. We have a plainly exaggerated claim for time spent by the claimant dealing with the case and a frankly inherently implausible suggestion that the minimal breach caused significant distress and worry and even made them feel ill. In my judgment, no person of ordinary fortitude would reasonably suffer the distress claimed arising in these circumstances in the 21st century, in a case where a single breach was quickly remedied. No credible case that distress or damage above a de minimis threshold will be proved. In the modern world, it's not appropriate for a party to claim, especially in the High Court, for breaches of this sort, which are frankly trivial. And we say very similar points can be made in relation to the present case. And in some ways, Rolf was a fortiori the present case. I appreciate I shouldn't use Latin, I apologise. There was no dispute that there had been publication of the personal data in question, and if anything, the data was more sensitive. Yet, notwithstanding this, the defendant was granted summary judgment on the basis the claim did not overcome the threshold of seriousness. Now, the ICO, in its analysis of this case, endorsed the court's conclusion, albeit not the threshold of seriousness reasoning. The ICO suggests that this is a good example of a rejection of an asserted level of non-material damage. It was, in substance, a finding that no recoverable damage had been suffered on the facts, and there was accordingly nothing to compensate. That sort of robust engagement with such claims is entirely proper. So even if you're against me on the threshold of seriousness, we say you can dismiss all these claims with this robust engagement that is required. I appreciate there was just one case in Rolf and you got 400, but the fact that 400 claims have been issued can't mean that we can't strike them out.
But Master McLeod does seem to have looked at it on the basis that she was looking at it was a threshold case. So she seemed to be paragraph 13, isn't that what she says?
Absolutely, my lady.
So she took the view that it fell below a threshold, yes, which she identified. I mean, I've got your point that in the alternative, and I've got the ICO's point that if that's not the right legal approach, then you'd say this is just a no damage case. Yeah,
yes, I completely accept that the Master considered this on a threshold of seriousness, yep, approach, and there is an argument about whether that should apply. We obviously say it should, and a similar analysis results in the claims going. But even if we lose on that argument, we have the fallback position with support from the ICO. And I appreciate the ICO is not addressing any of the individual claims, but the point the ICO makes, we say, is of some relevance, and we adopt it. Paragraph 19.2 of my skeleton argument, I deal with a case of Driver against Crown Prosecution Service, which is at tab 26 of the bundle. Now, again, we say this is a more serious case than the present case because the personal data in question was clearly published. It was sent in an email. and it is more sensitive because it concerns the fact that the claimant was the subject of a criminal investigation. The factual background here is a CPS lawyer sent an email out stating that the claimant was a suspect in a criminal investigation. The claimant had a degree of profile. He was a local politician, and he was very unhappy about this and issued a claim asserting that he was very distressed about the matter. And you'll see at paragraph 168, court concludes, I'm prepared to accept that the claimant would have experienced a very modest degree of distress upon discovering the CPS's email has been sent to his political opponents and the media by someone who had a grievance against him in an effort, as I find, to embarrass him. So it's essentially malicious disclosure of sensitive personal data. It is something that is obviously profoundly embarrassing. You don't want it disclosed to anyone, let alone your political opponents and the media. But for the reasons I've given, I rejected evidence that it represented some fundamental sea change in the complexion or likely outcome of Operation Sheridan, such that it could reasonably or properly have caused him anything like the level of anguish which he claimed. Except he consulted his GP in 2020, as he said, but I'm unable to conclude as a result of the emails, rather than, for example, the stress of being under police investigation by them for 6 years or so. Accepted not personal injury, no medical evidence. And in that case, a modest award of £250 was made, which is perhaps not surprising given the existence of publication and the very sensitive nature of the information in question. But again, the court was very willing to not take what was said at face value.
And how does that help you? I mean, this is a case where there was very modest distress on the judge's findings. He rejects a lot of evidence, but he finds very modest distress. If there was a threshold of seriousness, this claim would have been dismissed. It fell so far short of the alleged harm.
Well, my lord, I accept that I think Rolf is more on point and more helpful. The only point I extract from the driver case is the willingness of the court to reject evidence as exaggerated, which I can really take from the Rolf point. So I'm not sure I need to.
Yeah, this was after a trial.
Yes, my lord. I accept that. So on reflection, I don't think it really adds too much, my lord. Two further domestic judgments I wish to look at briefly. Firstly, the Prismal case. We referred to the High Court judgment in our skeleton, but since then we have had the Court of Appeal judgment, which is at tab 34 of the bundle, page 853. And paragraph 1 explains what the case is about. My lord, this is not a data breach case, it's a misuse of private information case. But the reason I'm taking you to it is it sets out the Court of Appeal's understanding of what the Supreme Court decided in Lloyd and Google. So it's dicta. We say the Court of Appeal's understanding of Lloyd and Google accords with our understanding, and you'll see in a section that begins representative actions at paragraph 52 on 863, paragraphs 54 and 55 deal with Lloyd and Google and the court's understanding of it, and the critical point is the last sentence of 55, where the Court of Appeal expressed a view that there was threshold of seriousness to be crossed before a breach of the DPA in 1998 gives rise to entitlement to compensation. Doesn't take us particularly far, I accept that, but there is a dispute about what Lloyd and Google decided, and here the Court of Appeal are opining that it decided what we say it decided. That's all I take from that. And then the final case I wanted to take you to is at tab 12 of the authorities bundle.
Was that Johnson?
Pardon my
Which case is that?
It is Ambrose Sialdu and Coward. I'm sure I've mangled that terribly, but
Ambrosiadu.
thank you, my lords.
Sorry, can you give me the tab number again?
Tab 12, page 240 in the authorities bundle. This also is not a data protection claim. We rely on it again for some dicta, which we say is of general applicability. This is a privacy claim. Factual background is set out in the head note, but I don't think anything really turns on the factual background. Paragraphs 27 to 34 address the issue, the extent to which Article 8 is engaged. And paragraph 30 is what I wanted the court to look at, particularly the last 2 or 3 sentences where the Court of Appeal say, just because information relates to a person's family and private life, it will not automatically be protected by the courts. For instance, the information may be of slight significance, generally expressed or anodyne in nature. Whilst respect for family and private life is of fundamental importance, it seems to me the court should, in the absence of special facts, generally expect people to adopt a reasonably robust and realistic approach to living in the 21st century. And we say a similarly robust and realistic approach to living in the 21st century should be applied in the context of data protection claims. Misposting a mail is not an uncommon occurrence in the 21st century. It is generally no more than a minor annoyance. It is not something that leads to catastrophic consequences, absent special features. So obviously, if the mail contained very sensitive personal information, for example, HIV status, or very sensitive financial information, special facts, you may be in different categories. But this is anodyne information that doesn't take you into special facts. And expecting reasonably robust and realistic approach, nothing more than a little bit of annoyance. It is a reasonable reaction, we say. Turning now to the European Court, the European judgment. Can I ask the court firstly to turn to tab 39? The UI Osterich Post AG case that you have been taken to.
Tab number, sorry, I've lost
Tab
it.
39, my lady, page 947. The case begins. Now, factually, this was a very different case, as was explained yesterday. It wasn't a publication case. It was the concern related to the association of the claimant with a particular political party by processing. Now, yesterday, my learned friend emphasised that this claim was a no disclosure case and suggested somehow that that would assist in their case, but they're not directly analogous. It is a no disclosure case, but it doesn't assist the claimant because the claimant's case today is based on fear of misuse. It's predicated on a possibility of disclosure, and the UI case was nothing of that sort. It was a completely different type of case. So it doesn't assist my learned friend on that, my lord. Now, you were taken to the Court of Justice's judgment, but we also have the Advocate General's opinion. And both are, the court can have regard to, neither is binding. And I think it would be of use to look at the Advocate General's reasoning, which we say is more persuasive than that of the court. And obviously, pre-Brexit, that would be a heresy to run that argument. You'd be bound by the ECJ judgment, but it's a perfectly acceptable argument now. You may reject it, but the Advocate General's opinion is of persuasive force in the same way the court is. And we say, properly analysed, it is more persuasive.
I may have missed this. Is that something you base on the European Withdrawal Act, or just as a general proposition?
It's a general proposition flowing from the Withdrawal Act.
Because the Act says something about decisions. I didn't think it said anything about Advocate General's opinions. I'm not saying you're wrong.
No, but my lord, even if that is right, Advocate General's opinions were previously persuasive, because often they were handed down. You didn't have a judgment of the court, and domestic courts regularly followed them. So it does refer, it's not bound by any principles laid down or any decisions made by the European Court. I suppose it depends what is meant by the European Court there, whether it includes the Advocate General, and to that I don't have an answer. But I don't think anything turns on that, because the court can consider anything that it considers relevant and persuasive. It could consider judgments of the French court as persuasive if it was of particular relevance. So I don't think we need to detain ourselves sort of drilling down on that particular point.
No, thank you.
Paragraph 14 of the Advocate General's opinion sets out the various questions that he's considering, and it's the third question that matters, and he addresses that question at paragraph 95 through to 116, which is at page 961 to 962 of the bundle. And we say he engages in a more detailed and we would say more persuasive analysis of the relevant provisions. He addresses the language of Article 82 and the various recitals that are referred to. He discusses recital 146 at paragraph 102 to 103. Recital 146 says concept of damage should be broadly interpreted in light of the case law of the Court of Justice, a manner which fully reflects the objectives of this regulation. He comments, I'm not sure that instruction would have been particularly helpful in the context of data protection, for the court had yet to rule on the subject when GDPR was adopted. If the intention was to refer to judgments of civil liability governed by other directives, it would be useful for that to have been flagged up. And at paragraph 108, he concludes that a threshold of seriousness that should apply, and paragraph 109 through to 116, there are his reasons for that. And again, it reflects the domestic thinking. I took you to what I'm going to call the coward case, where it talks about you've got to bear in mind the reality of life in the 21st century, and that's very much what he is saying here. it's not every claim for upset, anxiety and so forth that should found a claim. Now the court's reasoning is at paragraph 43 through to 51, that's page 978 to 979. And you've already looked at this. And our point in relation to this is the focus is very much on the importance of harmonisation and ensuring a consistent and homogeneous application of the rules across the EU. But that is not something of fundamental importance to domestic courts when deciding whether this is or is not persuasive, particularly when there is a clear line of authority that we say applies with equal force to the new regime, that there is a threshold of seriousness. Now, my lord, I accept, my ladies and my lord, I accept that the approach in UI has been repeated in a number of subsequent CJEU judgments. They're referred to in the ICO's submissions, but I don't think they really add that much. They don't take the matter any further, and nothing further was extracted from those judgments. So we say you've got the court, the Advocate General, two matters the court can take into account, have regard to the extent it wishes, but we say the Advocate General's is consistent with the domestic approach and is the more persuasive. So that's all I wanted to say on the EU. Turning now to issues of principle. As I said earlier, we say the court is bound by the Supreme Court in Lloyd and Google on the existence of a threshold of seriousness under the DPA 1998 Act. We, of course, accept that's not binding on the GDPR. However, for the court to conclude that notwithstanding the existence of a threshold of seriousness under the 1998 Act, there is no such threshold under the GDPR, the court needs a principal basis for distinguishing the two statutory regimes. And we say there is no fundamental basis for distinguishing between the two regimes. There's no fundamental change of language between the two legislative regimes. There's nothing in the 1995 Directive or the 1998 Act that refers to a threshold of seriousness. In the same way, there's nothing in Article 82 of the GDPR and 169, the Data Protection Act 2018. Nothing in the language of the underlying statutes is different. Now, the court in UI and the appellants and ICO in this case place reliance on recital 146 of the GDPR, but there are similar recitals under the 1995 Act, so that's not another principled ground for distinguishing the two regimes. My ladies, you have some of the 1995 Act, but it doesn't include the critical recital. So if I could hand up a one page for everyone. My lady, I've inserted this in the bundle tab 1 of the authority bundle, where the 1995 Act, 1995 Directive is. I've labelled it 4A and 4B.
Could someone send an electronic copy? Because I try to work electronically.
Of course.
Paper just got lost.
Yes, I will ensure that is done, my lord. I do apologise, it should have been done.
That's fine.
It's my fault. And it's recital 55, which we say is a similar type of language to recital 146. And it's the second clause of the first sentence. Recital 55 says, whereas if the controller fails to respect the rights of data subjects, national legislation must provide for a judicial remedy. Whereas any damage which a person may suffer as a result of unlawful processing must be compensated for by the controller. So again, the recitals say any damage, but notwithstanding that, the Supreme Court in Lloyd and Google thought a threshold of seriousness should apply. So the recitals are not a principled reason for distinguishing the Supreme Court reasoning. It's common ground that the threshold of seriousness applies to privacy torts, the misuse of private information, and a claim for breach of a convention right, the right to respect for private life. Now, it is said by the ICO that you can't draw parallels with those regimes because they're not statutory claims and the language of Article 82 is important. But domestically, Article 8 claims are statutory claims. They're claims under the Human Rights Act. And provisions of the Human Rights Act provide for damages claims. And like Article 82, they make no mention of a threshold of seriousness. Yet it's common ground that a threshold of seriousness applies in those type of cases. Similarly, or further, both the ICO and the appellant accept Jamil abuse of process arguments can be advanced, but there's nothing in the language of Article 82 or the recitals that suggests that is permissive, is permissible. And we say similar point applies to the threshold of seriousness. The relevant threshold does not, as the ICO, need to be arbitrary, and we're not suggesting that it ought to be. It's applied without any real difficulty to other causes of action, and there's no reason in principle why it can't be applied in this field. And we say the ICO and appellant's approach undermines the coherence between the different causes of action when it comes to assessing damages. This is the point Lord Justice Warby made when he was in the High Court in the event against Warby's case. That if possible, there should be coherence between similar causes of action. It's not a significant point, but in reality, all the points the ICO advances could be advanced in relation to the Data Protection Act 1998. The thrust of the ICO's case is the Supreme Court were wrong in Lloyd and Google to conclude the threshold of seriousness applies to that act, but they did so conclude. And if there is no threshold in this area, there is a real risk that the County Court and the High Court will be flooded with vast numbers of essentially worthless claims, which also concern a complex, developing and specialist area of law, as the present case shows. The point is not that only lower courts or different tracks should be bothered with these claims, but generally the court should not be. So we say the court must bear in mind policy reasons for having a threshold of seriousness in the other regimes. Those policy reasons apply with equal, if not greater force, in relation to this act, to the GDPR and the Data Protection Act 2018.
Could I ask a question about the recitals?
Yes, my lord.
I don't think we've been taken to 85 of the GDPR. I may be wrong about that. On page 20 of the authorities bundle, this is about notification of a data breach, but it describes what can happen if a data breach is not addressed in an appropriate and timely manner.
Yes.
In a way that struck me as potentially relevant, because it says that such a breach may result in physical, material or non-material damage to natural persons such as, and there's a whole lot of illustrative examples, non-exhaustive, no doubt, ending with professional secrecy, loss of confidentiality, or other significant economic or social disadvantage. The word significant struck me as potentially significant. In identifying what is meant by non-material damage.
Yes, my lord. I would say paragraph 85 is supportive of our argument rather than undermining it. Was that your point?
Yes, I'm not trying to help anyone. That's what the answer is.
No.
It just struck me. I wanted to hear what anyone has to say about that, because it could be used as a point in support of the notion that whether or not there's a threshold of seriousness in defining what non-material damage actually is, it has to be something of that kind.
Yes, my lord, and then we're perhaps getting into semantics. If the definition of
you could say it's a backdoor way of achieving the same objective, but one interpretation of the way that the CJEU authorities are going at the moment is that there's a little bit of wavering over this. We know that the CJEU, first of all, doesn't have the same sort of approach to precedent that we do, and sometimes makes decisions that seem to be not wholly harmonious with one another. It just struck me that there may be a bit of backsliding.
Well, yes, obviously, to the extent you're going to look at the Luxembourg jurisprudence, you need to look at it as a whole, and the most recent judgment, which we took you to yesterday, the BL judgment, I think could be characterised as a sensible refinement on the earlier case law. But as we explained yesterday, that case is very much on point and sets out general principles that, when applied to the present case, give the court an easy answer that these claims should be struck out without the need to delve into the individual particulars.
Yeah.
That's all I wanted to say on threshold of seriousness. Turning now to Jamil. My ladies and my lord, we address this at paragraph 20 of our skeleton argument. The existence of this basis for striking out claims is not controversial. Both the appellant and ICO accept it is available to respondents to advance. The court below summarised the principles of paragraphs 111 to 115. That's core bundle 77 to 79. You were taken to that yesterday. I don't think I need to take you back to it. I just wanted to briefly take you to the Jamil case and flag up a couple of paragraphs that I don't think were looked at. And Jamil is at tab 8, beginning on page 120. And the paragraphs I want to flag up to the court are at 54 and 57, my lord. The point at paragraph 54 that I don't think you were taken to is that in a post-CPR world, it's no longer the role of the court simply to provide a level playing field and to referee whatever game the parties choose to play upon it. The court is concerned to ensure that judicial and court resources are used appropriately and proportionately in accordance with the requirements of justice. Proportionality is key, and we can derive a similar point from paragraph 57 and the citation of Schellenberg against BBC. Reference to the importance of the overriding objective and proportionality, reference to costs at stake, court time, and very limited possible benefits. In paragraph 57 we have the metaphor the game is, whether the game is worth the candle, which you've already been referred to. So we say fundamental to Jamil is proportionality. The court is required, and I don't think it's controversial, to consider whether there is a Jamil abuse on an individual rather than a collective basis. The fact that some of the claims are abusive doesn't render all of the claims abusive, we accept that. But of course the fact that there are over 400 claims is relevant when considering the issue of proportionality. There is an even greater need or concern to ensure proportionality in the present landscape, whereby the Supreme Court in Lloyd and Google has made clear that individualised assessment of damages is required in claims such as the present, which has the potential to cause even greater sums of money and more court resources to be expended, and particularly where data breach claims are being issued by often huge numbers of claimants encouraged by law firms promising an award of damages. The appellant suggests that the claims could be transferred to small claims court after High Court determination of liability. So further High Court time followed by in excess of 400 county court claims. We say that's not an appropriate use of judicial and court resources. It's completely disproportionate for the most trivial of events where it is now common ground being no disclosure to third parties. The appellants must at all times have appreciated that this was a completely inconsequential incident. That's all I wanted to say on Jamil, unless there are any questions for me on that. And I will move on to actionable damage.
Yes.
My ladies and my lord, you've already been taken to the relevant provisions. It's Article 82 of the GDPR, which is at tab 4, page 37. And Article 1 says, any person who has suffered material or non-material damage as a result of an infringement of this regulation shall have the right to receive compensation from the controller or processor for the damage suffered. So material or non-material damage. And then we have at the following tab, tab 5, section 168, which is at page 60. Section 168, subsection 1, where the provision says, in Article 82 of the GDPR, brackets right of compensation for material or non-material damage. Non-material damage includes distress. Now, the appellants say the use of the phrase includes distress makes clear that it's not limited to distress, and we can claim damages for frustration, anxiety, mere upset. We say that argument is wrong. We say it's inconsistent with the Luxembourg case law that we've just looked at. But this provision has been included, we say, it included in section 168, in light of the case law under the previous regime, where claimants under the previous regime were entitled to claim damage for distress only if pecuniary loss could be established. And as the court is no doubt aware, the Court of Appeal in Vidal Hall disapplied a restriction to that effect in section 13.2 of the DPA, and held that distress could be claimed by itself. And the purpose of section 1681 is to make clear that what Court in Vidal Hall held under the previous regime was still the case. It wasn't to suggest that any emotion, however minor, frustration, annoyance, mild anxiety, could lead to a claim. And you can see that from recital 85 and the European case law, as well as the domestic case law. Now, the appellant in their skeleton at paragraph 102 criticised the respondent's position as being inappropriately wedded to the concept of distress and ignoring the fact that non-material damage includes the factual situation where a claimant is in some way worse off, either mentally or emotionally. We say that you can't claim for non-material damage in those circumstances, whilst the legislation says includes distress, and we accept it's not limited to distress. We say non-material damage does not extend to lower levels of emotion, annoyance, irritation, upset or mild anxiety. It's not limited to distress. It would include serious psychiatric injury, for example, which goes beyond distress. So there's nothing we say in the language of 168 or Article 82 that permits claims where no distress has been suffered. And again, that argument accords with the ICO's broad thrust, where, for example, their analysis of the Rolfe case, and paragraph 3, the ICO in their written submission says, not all emotional responses to an infringement of the UK GDPR, it should be just the GDPR, will constitute recoverable distress or non-material damage. So we say our submission is in accordance with the ICO position. My lady, my lords, that just takes me to the issue of repetition, which I can take quickly. Deal with that at paragraph 22 of our skeleton argument, which is at page 139, and that is to be read with our annex, where annex to our skeleton argument, where we pick out certain phrases. I know you've read it, so I don't need to repeat it. And at paragraph 22, I set out a paragraph from Mr. Justice Fancourt in the Duke of Sussex case, where he said, I'm concerned about the way in which the claims of claimants like Mr. Sanderson and Mr. Turner have been conducted. Pleadings and witness statements often appear to say what is needed to advance a claim, rather than what the claimant or witness can properly recall. The claim is maximised without apparent regard to whether it is realistic. And we say similar points apply here. Of course, except that the individual particulars of damage are not witness statements. I wasn't suggesting otherwise, but they have been drafted in a way to essentially suggest that you are looking at what the individual words are, and the reappearance of certain stock phrases between them, we say is troubling. And you've got it, we've set that out in detail in the schedule. I don't think there's any point me taking you through that, because you've already no doubt looked at it. I'm now going to move on to, that's all I wanted to say about the law. I'm just going to check with my junior to see if I missed anything. So now going to turn to submissions on why, applying the law, the court should strike out all these claims. I'm going to deal with it first by way of looking at the generic facts, and then briefly by looking at a very good example of the individual cases orally. And I deal with this at paragraph 23 through 36 of a skeleton argument. We say, although obviously Mr. Justice Nicklin concluded that these claims failed on the basis of no real processing, in fact what he may well have been driving at are the points now relied upon by us in the present case that the claims are not sufficiently serious, there is no real damage established, and they're not capable of giving rise to a real or substantial tort. It simply cannot be the case that police officers used to contending with dangerous and upsetting situations have been genuinely distressed over a pensions forecast being sent to an old address. Further, to allow any of these claims to continue to a full trial would be highly disproportionate and a concerning waste of valuable court time and costs, a considerable amount which has already been expended on this claim. This was an unintentional, one-off, and we say quickly remedied incident of a non-damaging nature. It's precisely the type of trivial technical breach that may well attract law firms on the lookout for new cohorts of claimants, but which should not be troubling the court. It's an inescapable aspect of this litigation that there are a large number of claimants. A decision was made for over 400 claims to be issued, and D can do nothing other than respond to their respective cases on damage on an individual basis. See Lloyd and Google. The number of claims alone is not a basis upon which to dismiss D's application for strikeout or summary judgment. In any event, the appellant's pleaded case on damage is now very limited indeed. It's based, my lord, you took my learned friend to the pleadings. It is very much a limited basis, and the court has before it undisputed fact, which we set out in our skeleton argument and took the court through yesterday, from which it's possible to conclude that each appellant's plea regarding the damage allegedly suffered by him or her can be found to lack all reality and credible grounding.
That's the summary judgment argument.
Yes, my lord.
Fanciful.
The present proceedings cannot continue on the basis of vague references to what might lie within the individual particulars or what evidence might be produced at trial. The claimants were ordered by Master Dagnall to plead their case on damage in full. You'll see that from the recital, and have had every opportunity to produce evidence in their own to dispute any of the facts relied on by the defendant, knowing the nature and extent of our application. The court, of course, does not need to grapple with whether any of these ABSs were open, and if so, to what extent, by whom, and for what consequence. We say it is now common ground that none of the ABSs were read by anyone. If claims of this nature, particularly where the personal data in question is not sensitive, are found to get over the threshold of seriousness, or found to survive Jamil abusive process, or found to amount to real damage, it's very difficult to imagine what claims in this area will fail. Correspondence being sent out to outdated addresses is a commonplace part of ordinary life for all of us, and the courts expect persons generally to adopt a, quote, reasonably robust and realistic approach to living in the 21st century. One might reasonably expect police officers in particular to be robust enough to escape such an unremarkable incident unscathed. We rely on all the circumstances of the case, which I took you to yesterday and are set out at paragraph 6 to 10 of the skeleton, in contending that the ABSs being posted to an old address cannot possibly have given rise to harm seriousness to overcome the relevant thresholds or to justify the continuation of these proceedings. In the case of each claim, the essential and undisputed facts are followed. Information, which is of limited nature, in the words of the ICO, or slight significance, words used by the Court of Appeal in the Coward case, and often publicly ascertainable concerning the appellant, a public servant's pensions forecast, sent in an opaque envelope, which did not identify them as a police officer, to one known address, which the claimant had previously supplied. Given those facts, which are not in dispute and are to be approached objectively, including the nature of the information, the fears and concerns referred to in each of the individual particulars are, we say, entirely irrational, and the levels of claims distress referred to entirely improbable. The court is entitled to have regard to any inherent improbability, and it's not the case that the claimant can simply make assertions being highly distressed and automatically succeed in defeating our application. To take one example, the repeated assertion by a number of the claimants would cause distress over being identified as a police officer It's entirely improbable since, as they well knew, nothing so to identify them was visible through the envelope's window. Nothing in the ABS referred to their rank or particular deployment area, and they didn't assert in the claim that the fact that they were a police officer was personal data on which they were relying upon, or private information which they were relying upon. And the nature of this argument becomes more absurd when one considers that although this claim is based on the sending of one letter to an out-of-date address, and there's a number of them, a large number of them say, I don't tell anyone I'm a police officer, or I tell very few people, I keep it very quiet. They're saying very distressed by this one letter going to this, but then on the other hand, they're prepared to tell the world by bringing a claim where they're identified that they are police officers in Sussex. There is a fundamental inconsistency.
But they didn't want to be identified, they asked for anonymity.
Yes, my lord.
They were forced to
And the court
unmask themselves.
rightly rejected the argument that in relation to every claim bar 9, there was absolutely no basis for anonymity.
Yeah, but I mean, they didn't act inconsistently. The court didn't let them act consistently.
Well, they acted inconsistently by, when they were told you're not going to be anonymised, continuing the claim. That is the point. They acted inconsistently, my lord. If they were, as they suggest, absolutely distraught about the possibility of the fact that they were a police officer being revealed to the general public, they would have withdrawn at that stage. And of course, it's not only their identities that are not subject to an anonymity order, but the individual particulars are open to disclosure to the press and the public. There was some discussion about an application pursuant to CPR 5.4c in relation to those, and you'll see from Mr. Justice Nicklin's judgment that he rejected that. So by continuing the claim, the police officers have decided to put the fact that they are police officers in the public domain far more widely than the letter that's complained of, and also disclose lots of information about them working in sensitive areas, apparently being in counter-terrorism, firearms, etc., etc. They have elected, by continuing the claim, to put that in the public domain, when that is far, far more sensitive and far, far more serious than the information in the ABS. So we say that is something you can take into account when considering the reality of this claim. Now, can I just ask you to turn up the master particulars of the claim at CB 269? I've given you the wrong page. Apologise.
251.
I think it's a core bundle.
Core 22 251.
Yes, it's the core bundle at 269. I was meaning to take you, not the supplementary bundle. I apologise. At 12.1a, you have the extent of the claim for particulars of damage. And we say the claimants are limited to what is said here. They had an opportunity. The court invited them to amend at the permission stage, and they did so. So there is no scope for going beyond this. And you'll see claimants have been caused anxiety, alarm, distress, embarrassment by the fact that the personal data may have passed into the hands of unknown third parties, and or as a result of uncertainty as to what has become of their ABSs and who may have opened it, and or by the fact that their personal data may be or may have been misused. Well, we say anxiety, alarm and embarrassment are not viable claims under the GDPR. The way it's pleaded, passed into the hands of unknown parties, it's not clear why the fact of data potentially passing into someone's hands, as distinct from actually being read and then misused, would cause distress. Is someone really distressed if they know an envelope that's unopened has been sent to the wrong address? It's surely, it's only if it's going to be opened that there can be any credible claim. It's also far from clear why the claimants use the language of unknown third parties, where it's an important and agreed fact in these proceedings that each ABS was sent to one known formal address, as the ICO also fully appreciated. Finally, save perhaps for the period of time up until they heard from the defendant or police or located their ABS, this line of argument is completely nonsensical in a significant number of claims, whereas detailed above, the relevant appellant was informed by the respondent or the police force that their ABS had been returned unopened or they had themselves retrieved it. In any case, this fear of the unknown point completely falls apart in every case when proper regard is had to what each of the claimants knew or must have known from the outset. It's simply unreal to suggest that any of the claimants held a genuine belief as to their data having gone to someone unknown, let alone read to any meaningful degree or actually misused, that any real distress arose as a result of such a belief. In that regard, each appellant knew, one, precisely where their ABS had been sent, i.e. their former address, so they could, if they wanted to, easily retrieve it. A number of those individuals chose to do that. This is not a case in which appellants have no way of knowing what might have happened to their data so as to give rise to worry and uncertainty. It's not a publication on the internet case where they may not know who has access to it, who looked at it, and so forth. If they were genuinely concerned, they could, and some did, very easily track down that data and get all the answers they needed. They were also well aware that the ABS envelope was marked private and confidential, showed their name, not the unintended recipient, and gave no indication that it was anything other than everyday correspondence of no concern at all to anyone other than the named appellant. In addition, the first page of the ABS contained entirely anodyne information clearly directed at the appellant. We say that the claimants must be confined to their pleaded case, which refers to only the ABS passing into a third party's hands as opposed to being open, read and misused. In any event, the claimants must have appreciated the likelihood of their ABS not only being opened by someone else, but also being read to a meaningful degree was vanishingly low. As the court said, and I put you to this yesterday, paragraph 150 of the judgment, absent some facts that will compel a different conclusion, the court will not draw the inference that a letter addressed to a named recipient, clearly marked private and confidential, will be opened by a third party who is not the named recipient or authorised by him/her to open correspondence addressed to the named recipient. In precisely the same way that the inference of publication is unreasonable in the circumstances of the present case, so are any concerns about potential publication. They would also have known that the ABS did not contain sensitive data such as health data or data of usernames, passwords, PIN numbers, from which misuse might possibly flow. In other words, C must have appreciated the distinction between their data passing into the hands of unknown third parties and those third parties actually having the inclination to misuse the data or having the capability to misuse it. In this regard, Nicklin, Mr. Justice Nicklin held, paragraph 42 of his judgment, some common themes emerge. For example, the fear that the relevant claimant would be a victim of identity theft. The evidence filed by the claimants has not demonstrated that this apprehended fear of identity theft has materialised. Not one of them has referred to any evidence of that. Some of the claimants have in their individual schedules raised concerns about receipt of spam emails or suspicious financial transactions. But given that neither email nor financial information was contained in the ABS, difficult to see how that could be attributed to any misuse of information from the ABS by a third party. It's one thing to have concerns, but it's quite another for those concerns to be rational and capable of being substantiated given the known and undisputed facts. Fourthly, it would be known to the appellant that even if the ABS had been read to any meaningful degree, it would most likely have been read by one person or a very limited number of people, in contrast to the disclosure on the internet. Fifth, that their ABS had not been sent to anyone with a particular propensity towards misusing the information. In fact, in the case of 61 of the remaining claimants, it's pleaded that the ABS was sent to, and in all but 7 of the cases, received by a family member, acquaintance or colleague, to use a phrase from defamation law, someone in their own camp. In the event, it must have been appreciated that the average person who receives and mistakenly opens a letter addressed to someone else is highly unlikely to misuse that information contained therein, even if, which is denied, the information contained within the ABS was actually capable of such misuse. The claimants, the appellants may be avid to scandal, but the court does not have to accept fears and concerns which only an entirely irrational person would have. And the appellants would sixthly also have known that the incident was spotted and dealt with quickly, including by way of notification to the appropriate regulator, the ICO. Each claimant was promptly notified of the incident and given reassurances and offered CFAS protection, as well as being subsequently updated. Claimants were not left in the dark with no idea what might have happened to their data or what was being done to put the situation right. In addition to those 6 points, it's reasonable to assume that the claimant will have been aware of each other's position. This includes the important fact that no case of actual misuse of the information contained in the ABS has ever been advanced by any of the original cohort of claimants, even those 14 who alleged that their envelopes had been opened. In fact, as to the remaining claimants, they must have been reassured to know that in every one of those 14 cases where there was evidence of opening, the ABS was handed back to the relevant claimant. In 12 of those cases, the ABS was said to have been opened by a relative before being passed to a claimant. In one of those 14, it was received by another police officer. In only one case, that's C200, was it said that the ABS was opened by someone other than a family member or colleague. And none of those 14, including C200, advanced any case as to the misuse of the information contained in the ABS beyond an inferential one. In any event, the allegation in each inferential case was based on or centred around use of information not actually contained with any of the ABS's banking information, contact information. The individual particulars you have in the bundle, the 4 unagreed bundles, and to an extent in the supplementary bundle, produced years after the event and contain concerning levels of repetition. By way of highlighting this issue, 2 of the original claimants discontinued, and we're going to look at these briefly, C146 and C248. One of those brought a claim and signed a statement of truth in relation to a schedule when it turned out they weren't even a member of Sussex Police, and another signed a detailed schedule when they hadn't been receiving ABSs since 2013 because they weren't an active member of the pension scheme at the time. It's clear, having regard to the particulars of those particular claimants, that even in circumstances where there was in fact no misdirected ABS at all, the same stock phrases concerning distress were simply repeated. This is a real concern and causes serious doubt on the authenticity and credibility of the pleadings as a whole. By contrast, the contemporaneous evidence, which we would emphasise the court should look at, barely any, only 37 of the claimants took up D's offers, the respondent's offer of free CFAS protection, despite now claiming to be highly stressed over the possibility of identity theft. Only one of the claimants, that's C1 Michael Farley, made a formal complaint at the time, and none of the claimants sought medical assistance specifically in relation to the incident at the time of it actually occurring. Rather than pleadings produced years after the event or witness statements drafted by the claimant solicitors, such evidence provides a far more credible insight into the distress actually suffered by the claimants at the material time, or the complete lack thereof. we say it is in the interest of the parties, the court and justice generally that claims based on unreasonable, unsubstantiated inferences and speculation are halted now before further very significant expense is wasted along with valuable court time. As was held in Rolfe, no credible case that distress or damage over de minimis threshold will be proved. In the modern world, it's not appropriate for a party to a claim, especially in the High Court, for breaches of this sort, which are frankly trivial. Put another way, the game is simply not worth the candle. That's all I wanted to say about the generic facts. I'm going to...
I think your junior perhaps wants to
Yes.
plug your gown.
Yes, my learned junior makes the point. Mr. Justice Nicklin's order gave any existing claimants an opportunity to make an application that their individual schedules should be withheld, pursuant to CPR 5.4c. And our understanding is no such application has been made by any of the claimants. Now, my lady, turning now to the specific, the individual particulars, we are at 20 past 11. I promised to finish by 12. I will still finish by 12. I do want to address a small number, but to speed it along, my learned junior has very helpfully produced a speaking note dealing with claims that have been raised by...
Has Mr. Campbell had an opportunity of seeing this?
Well, it was produced overnight, so not yet.
Well, we still had between 9 and 10 this morning for him to look at it.
Well, my lady, I didn't hand it to him, but I apologise. Benefit of hindsight, I should. What it sought to do is respond to particular claims that have been raised by the claimants at particular times. So some were raised orally yesterday, some were selected.
Well, is this effectively a supplementary skeleton argument?
Well, it just flags up the points in relation to individual particulars. It saves time, my lady. It means I don't have to go through orally various cases that have been raised by the claimant.
Well, just give me a moment. Yes, well, we'll look at it. I think you owe an apology to Mr. Campbell's team.
Well, yes, I apologise both to the court and to my learned friend and his junior. No disrespect was meant.
Well, if we go through all of this, we'll be here till Monday.
My lady, that's why we're not going to go through all of this. As I said, I just wanted to pick out 2 or 3 to save the court's time, because the court clearly doesn't want didn't want my learned friend, didn't want me to orally develop lots of these claims, and I just wanted to short circuit that. So the note is divided into 4 sections. The first, the purpose of the note is to address the various cases that we say the court should infer the appellants regard as their most serious cases. They're cases that have been raised by the appellants at various stages. The first 9 deal with the claimants that the appellants decided to put in the supplementary bundle. The second category were the most serious claims identified below as we understood it. The third category, which is page 21 of the note, relates to further claims relied upon during the hearing yesterday itself. And then section 4 addresses a sample of other claimants. I'm going to take you to a couple of those, my lady. So it was to assist the court and to speed our way through, my lady. If it doesn't assist the court, it doesn't assist the court, and I of course apologise.
No, I'm sure it won't. And more to the point, I'm shudder to think how little sleep Miss Appellant must have had preparing this overnight, and we're very grateful for all your hard work.
Yes, my lady, we thought, although we don't want to detain the court at length orally, given there are 400 claims being advanced and we are seeking to strike them out, we think we could be criticised if we didn't address those selected by the respondent in various ways as the most serious. Could I ask the court first to turn to the supplementary bundle and page 416.
416?
No, apologies. Yes, 416.
Thank you.
Now, I think the court may have already read this one because it's been placed in the supplementary bundle. And as I say, these were picked by the appellants. It's quite clear they weren't picked at random because in none of these 9 were the ABS is sent back unopened. So there clearly has been some cherry picking. And this is the first one selected, and no doubt it's viewed as particularly strong. But if one analyses it...
I'm sorry to interrupt. Just to be clear, that is certainly not the basis on which these have been selected. There was some discussion between the parties as tried to put a representative sample in the bundle, but these are not.
So these were chosen in consultation with the other side?
Well, there was discussion as to what should go in the bundles, as to whether it was necessary to have all the schedules before the court. And these were proposed by the claimants to be a representative sample. And the defendants, I'm not sure the extent to which they engaged on that, because they took the view that all of the schedules should go before the court.
Understood.
But they're not selected to be the strongest cases.
Thank you.
Well, yes, there was initially agreement that all of the individual particulars...
Well, you've told us that yesterday.
Yes. So if we can look at claimant number 45.
Yes.
Here, the ABS was sent to an address that was owned then and now by his ex-partner's parents, who are therefore known and presumably contactable at all relevant times. You get that from paragraph 6 on 417. Now, the fear that supposedly underpins the asserted distress here is that the ABS would be opened seen by an ex-partner and that they would misuse it in some way. But it's clear that there were tenants living at the property at the time, not an ex-partner. So for the ex-partner to actually see this information, the tenants would have to forward the ABS that was addressed not to the ex-partner or the ex-partner's parents, to the ex-partner's parents, the owner of the property, who then forwards it on to the ex-partner, who then opens it. That is a wholly implausible state of facts. There's no basis on which tenants would forward an incorrectly addressed letter to the owners if it's not addressed to them. It'll either go in the bin or be returned to the return address. And the suggestion that if it had gone to the ex-partner, she could use it it could be used, it could impact on childcare matters or be somehow relevant to the custody dispute, again, is utterly fanciful given the anodyne nature of the information. C's income as a public servant would have been ascertainable, at least broadly, as would the fact that the police benefit from very generous pensions. If one looks at what is said the ABS could be used for by the ex-partner, it really is wholly implausible. It suggests that it could be used to harass the new wife somehow, which would cause the new partner some stress and anguish. But on what basis could the information contained in the ABS be used to harass the new partner? It just does not make sense. That there is no bank details, there's no important financial information. Again, the bottom of page 418, claimant says distress because it could be accessed by criminals. Well, if he was concerned about being accessed, he knew where it was, he could go and get it. And he then talks about acting as a covert operative, and if personal details such as his address fell into wrong hands, he could be followed and identified. But the ABS doesn't contain his current address. It contains his old address, and that's not complained about as personal information. It just doesn't make sense. And if one applies any degree of rigour to this, one can see that. The claimant is saying, bottom paragraph 418, I'm very concerned if the fact I'm a police officer got out, I could be targeted. But yet, he's continued with this claim. And
well,
not
you have your general point about
yes.
anyone continuing the claim.
Yes, but there's a further point. He hasn't sought to withhold the information about him being a covert operative from the public. That is something he has chosen that can be disclosed in open court, not sought to prevent that. So we make quite a few points in relation to this. I've just flagged up what we say are the key ones, my lady.
Yep. Thank you.
Next one I'm going to take you to is 146, claimant 146. This is volume 2 of the unagreed bundle at page 829.
Eight two nine.
829, my lady. So this is an individual working road policing, and you'll see over 830 she talks about extreme annoyance and frustration about the apparent ineptitude of the defendant, and also talks over page 831, claimant suffered distress, claimant was advised by a family member who works in data protection, submitted questions to the defendant or to establish the extent of the data breach and potential ramifications. So there's talk about distress, anxiety, and so forth. But it turns out this claimant isn't a member of the Sussex Police. There's no misdirected ABS in this case. This individual should not have been a party to this claim. And when we pointed out that the individual wasn't a member of the Sussex Police, they discontinued the claim. So it's not one of the claims that we're seeking to strike at now, but it's relevant because if you look at this, it's no different to all the other pleadings. you have the same stock phrases, the same claim distress, and this is just completely misconceived.
Was this claimant one of the ones who got the letters saying we've made a mistake in your case?
My solicitors, this is referred to in our solicitor's witness statement, which you have in the supplementary bundle. We wrote to the claimant solicitor saying we don't think these should be claimants for various reasons.
No, I'm going back. I just want on the facts. Was this an individual who got a letter
from
Equiniti at any stage saying we made a mistake in your case, or from Sussex Police or anything like that?
No.
Okay.
No. I have no idea how or why they joined the class action, but they weren't sent a letter by Sussex Police because they're not a Sussex police officer. So that does raise real concerns about how much care has gone into the drafting of these individual particulars. And similar points can be made in relation to Claimant 248, which you'll find at volume 2, page 1372.
Sorry, I was not listening properly.
Page 1372 of volume 2. Now, this individual was a member of Sussex Police, but hadn't been an active member of the pension scheme since 2013. So since 2013, she hadn't been receiving ABSs because I understand they're only sent to active members. And when we pointed this out, this claim was also discontinued. But again, look at what's said here. Claimant manages some of the most dangerous people in society and now feels at risk. Prior to the breach and throughout the claimant's police career, taking special care to limit the information he gives about himself or his role with the police to anyone outside the immediate family. Claimant feels that both he and his young family could be at risk should the people he manages get hold of his personal information. Well, there's nothing in the ABSs that is going to put him at risk. But there wasn't an ABS missent in this case. So again, one really has to wonder how carefully these documents have been drafted.
They don't look like they're made up. I mean, this is, unless this is an entire fraud, this is someone who was believed by whoever wrote the document. And presumably by the person themselves, because they put a statement of truth to it, to have been sent an ABS to the wrong address, and they know what the address was because they've said they were there for 18 years. It is all puzzling and troubling in a way, but what are we to make of it all?
Well, we say, and that there was no misposting in relation to this case, and we understand that is now accepted. But when we raised this issue...
We don't have to strike this one out because it's been discontinued.
Yeah.
But what implications does it have for those which haven't been discontinued, is my question.
Well, we say, if the type of particulars that are set out are the same, whether there has been misposting or hasn't been misposting, it tends, we say, to undermine... at least give rise for concern about how carefully the police who have put in particulars, how reliable they are. In relation to these two claimants, it might assist if we go to the supplementary bundle where this is addressed by my instructing solicitor, Mr. Richmond Coggan, and it refers to a letter that he wrote. It's page 176, paragraph 31 of the bundle. and when it was written that there had been no response, but shortly after this was written, claims 146 and 248 were discontinued, which we say clearly means they accepted that there had been no ABS misposted.
Which is your next claimant you want us to look at?
Claimant number 40, volume 1, 228. So begins at page 228. You'll see paragraph 5. This particular appellant, it was sent to an address that she owned. She sent her mother to recover it. She did recover it, and as far as she could ascertain, it hadn't been opened. So a type of case where you really would not expect a claim alleging great distress. But then you look at paragraph 7.1 and you talk about suffered and continues to suffer considerable annoyance, notwithstanding that she retrieved the ABS some 3 years ago. So how annoyance is still continuing, it is hard to tell. She's annoyed that she didn't receive the ABS as expected. Well, yeah, I accepted that that is a low-level annoyance, but it doesn't found a High Court claim. Then goes on to say the claimant's annoyance has been protracted and compounded by the defendant's inference that the matter is trivial. Claimant does not consider the matter to be trivial. Potential consequence of any individual of data breach is serious. So far as the claimant can tell, defendants have demonstrated a lack of accountability in their management of the resultant complaints, as well as providing no reassurance related to the competence of their future management. Well, it wasn't letters coming from us that said that the risk was low, that this was trivial. They came from Sussex Police, and that view was shared by the ICO. We do regard it as trivial. It is trivial. And that view is shared by both the police force and the ICO. But even if she is annoyed by the fact that we regard it as trivial, that doesn't come within the damage claimed in the master particulars, which derives solely from fear of misuse. So it's not a viable claim. And concerns about lack of accountability in management of the resultant complaints, this individual didn't make a resultant complaint. And didn't take out CIFAS protection. Yet she says, I suffered distress, notwithstanding she recovered it unopened very quickly from a property she owned. One just has to read these to see that they are clearly very exaggerated. And my lady, it's now 11:45. I could carry on, but I get the feeling from the court that you probably wouldn't derive much assistance from me carrying on.
We have got the benefit of your speaking note.
Exactly right. Thank you very much. Thank you.
No, thank you very much, Mr.
Thank you.
Farley. I should ask, do you wish to follow on this as well?
I'm grateful, but no.
Anything in reply?
There is, I'm afraid, my lady, yes. And I deal briefly, just because I happen to have it open, you may not, with the discontinued claimant 146.
So is that back to the bundle 2?
It is.
Just give me a moment.
829.
It's 829 it starts.
Yeah.
You see what she says at the top of 830, that the ABS passed on to her by her senior officer. She was on maternity leave at the time it was posted out. The claimant was informed by a senior officer that it had been opened by the recipient in order to ascertain who it was intended for. Now, if that's a fraudulent assertion and completely made up, it's a very curious one to say that that is what I was told by a senior officer when that could be easily disproven. So her claim, based on the thought that it had been posted out and opened, is based on what she was told by a senior officer. Transpires that it was not in fact posted out by the defendant, hence the case has been discontinued. But I struggle to see, without examining the facts of this very carefully, what this court can usefully glean from that. Even if it were right as a matter that this was an abusive claim and it was being brought fraudulently, that again is not something that should be held against the remaining appellants. The point made in the Mariana case that if just because one claim in a group action is abusive, the court's got to be careful about drawing any inferences in relation to the rest. But my main point is, without a close examination of the facts here, which of course this court can't do, little can be derived from that. I'm told actually in relation to that it was discontinued because the breach was at a different time. There was more than one
Yes.
set of ABSs being sent out to wrong addresses, but the breach did happen, apparently.
Well, it did occur to me that the non-Sussex police officer may have been subject to a similar breach by her own force.
Yes.
And so can't remember whether it was a him or her, but their expressed distress and irritation was as a result of a wrongly addressed ABS, but with a different force. But we don't know.
Yes. The wider point, ladies, I'm not in any meaningful position to respond to this.
Understood.
I haven't read.
I wouldn't expect to.
But what it does reveal as a broader point, my lady, is that there may well be cross-examination points for these claimants really to be called to trial as to why they thought what they did and how genuine it was. But the fact that we're looking at a 34-page analysis in relation to, I don't know how many of the claims this is, rather reveals, I would suggest, that this is an issue which would require a trial, or at least a trial of sample cases, to investigate exactly what happened in relation to these claimants. And broadly, in relation to the 14, that was the view taken by Mr. Justice Nicklin J.
Thank you.
Going back, though, my lady, to points made yesterday, the Media Mart case and Mr. Charland's submissions on it. As I understand what he was submitting yesterday, he says that as a matter of principle, a claimant cannot prove non-material damage based on a fear of misuse or publication, if in fact it is proved that there was no publication or misuse, regardless of when that becomes apparent. As I understand it, what he says is the principle to be derived from Media Mart. Though I'd suggest that such a principle does not arise from the decision and would have some very odd consequences were that to be the position. My Lord Justice Warby, yesterday afternoon towards the end of the day, postulated a scenario based on a spectrum of different scenarios of someone having an entirely rational fear that data may have been misused, and suffering serious distress as a result, but only discovering several months later that the data had not been misused or seen by anyone. Now, in that scenario, if Mr. Charland's principle was correct, that person would not be entitled to compensation because, in fact, it was proven that there was no misuse. But it would be a bizarre and unprincipled position, I suggest, for such a person not to be able to recover damages for distress that had been caused by the breach. But the claimant in, for example, the VB and Bulgarian National Revenue Agency case was entitled to recover for fears based on material being placed on the web with no evidence that it had been read by anyone. Why on earth, as a matter of principle, should the claimant in VB be able to recover, but not the claimant in the scenario postulated by Lord Justice Warby? The principle would also have some other odd and irrational consequences. Say somebody brought a claim for that he had suffered distress as a result of fear that his data had been misused, and it was discovered the day before the trial that the data had just been recovered and hadn't been misused. Would that mean, in those circumstances, the claimant couldn't recover because it had just been found out that it hadn't been misused? Whereas if the case had come to trial the week before, he or she would have been entitled to recover because the discovery hadn't yet been made. Again, if that is right, it would be a bizarre set of bizarre application of the principles. Can I ask you to turn to the Media Mart case? I know you have looked at it carefully already.
Happy to go back to it?
I think we placed it at the back of the second authorities bundle.
We did.
On the facts discussed yesterday, the court proceeded on the basis that the documents had not been read by the third party in the 30 minutes they were astray. And if I can ask you to turn to paragraph 63, page 2610 of the report. The court regarded that fact as being of importance to the case. You see there, important that unauthorised third party did not become aware of those data before the documents returned. Then if I can ask you to look at paragraph 66. The court notes that it had been held that the loss of control of the personal data for a short period of time may cause the data subject non-material damage, giving rise to a right to compensation, subject to that person having actually suffered such damage, however minimal. So the court obviously regarded that as still being an applicable principle based on UI and other cases. And loss of control can happen without proof that the data has been read. And in our case, the appellants we submitted did lose control of their data for more than a short period of time. Turning then to paragraph 67, what is said there is that non-material damage encompasses a situation in which the data subject experiences the well-founded fear, which is for the national court to determine, that some of his or her personal data may be subject to dissemination. The fact that it encompasses such a situation is not the same as a finding that it is a condition of recovery that the fear be well-founded. There is nothing in the GDPR which states that the fear being well-founded is a condition of recovery. And I'd suggest there is a risk of overcomplicating what is a simple, relatively simple statutory test and provision with the three elements of the cause of action that I outlined yesterday. Further, adding a condition that the fear be well-founded creates, by the back door, I would suggest, a threshold of serious condition which the court have consistently rejected. Yet further, if a need for the fear to be well-founded is added as a condition of recovery, there would be an inconsistency, or at least a tension, between such a condition and the eggshell skull principle. You have to take your victim, including his psychology and personality, as you find him. Assume a claimant suffers serious and entirely genuine distress as a result of a fear that his data will be misused, but the court concludes that some or all of that distress is not well-founded and arises because of the person's personality and particular emotional susceptibilities. Does recovery for that part of the distress, even if genuine, have to be excluded because it simply arises because of the person's personality? If that is right, I suggest it would be inconsistent with the eggshell skull principle. What I would suggest in summary is that the extent to which the fear is or is not well-founded simply goes to part of the factual matrix of whether the claimant is able to establish damage. And the court is not saying more than that in what it says in paragraphs 67 and 68.
Sorry, the extent to which the fear is or isn't well-founded simply goes to what?
It goes to part of the factual matrix of whether the claimant is able to establish damage. I accept when it comes to a court assessing the claimant's evidence as to whether the claimant has suffered genuine distress, the extent to which that distress could have resulted from the breach is something the court will take into account as a matter of fact. But that is different from it being a condition that it has to be well-founded or based on entirely rational response for recovery to be, there be an entitlement to recovery, because that would be adding a condition which is not in the legislation. On the facts, of course, we submit that the appellants have a perfectly good case that their fears were well-founded. It is of note here that over 400 appellants, strict claimants, say they had a fear arising from this breach. It would be a remarkable conclusion to find that all 400 or over 400 of those have fears that are simply irrational and groundless. It's why the respondent is forced into its submissions that the appellants are effectively making it all up. The way it was put by Mr. Sharland this morning was that they can't have been genuinely distressed, the claims are absurd, and the fears are entirely irrational. Now, that is what he would have to establish in order for it to be appropriate to give summary judgment for these in respect of these claims. But that plainly was not the view of the judge, certainly in relation to the 14. And I submit it would be a inappropriate and certainly very bold conclusion for this court to draw without looking at hearing any evidence that all these 400 police officers are simply making an assertion of distress or equivalent emotion which has no grounding in reality. Connected to that, it's important to note that the grounds that the appellants had for fearing their statements may be opened are fact and claimant specific. So, for example, one of the schedules I took you to yesterday, it's claimant 144, she pleads, or says in her schedule, that she attempted to recover the ABS and went to the address where it had been sent and was advised that it had not been received by the person she at the address, and she was concerned that she was being lied to. Now, her fear that the statement may have been misused is not entirely groundless and is based on a different set of factual circumstances from some of the others. Another example is claimant 299, who says that his statement was sent to the address of his ex-wife, with whom he was going through an acrimonious divorce. And he says that he has reasons to believe that his ex-wife was opening any post that was sent to him at that address and would use the statement to gain financial leverage.
I didn't really understand that. In a divorce, she's entitled to know what his salary is, what his pension rights are.
Well,
Is he seeking the assistance of the court to recover damages for a disclosure that he didn't make, and that he wishes he hadn't been forced to make by his mistake?
yeah, my lord, I understand that. And of course, this court is well aware that disclosure obligations in ancillary legal, whatever that's called these days.
Financial remedy.
Thank you, my
Happy
apologies.
to help.
Yes, understood. But that doesn't mean that his concerns as to what had become of it are, and that it may have been opened, are irrational. He may have genuine distress about it. It may be said, there'll be a cross-examination point, well, look, okay, yes, you're distressed about this, but you're in an obligation to disclose it anyway, so your distress is not one the court should countenance. But that's a fact-specific issue in relation to that particular case as to exactly what his distress was and the circumstances between him and his ex-wife. Mr. Shannon yesterday used the analogy of the box of chocolates being sent, and there's more likelihood of a box of chocolates being opened by a third party than an envelope with just an address on it. But it depends on all the circumstances as to whether that is right and what the likelihood is of the envelope being opened. Mr. Shannon this morning said that part of the factual background is that it was known what third party the letter had been sent to. But that isn't right as a matter of fact, because the appellants often did not know which former address the statement had been sent to and who was living there. And it's also said that it's clear as a matter of fact in all these cases that it was sent to somebody without a propensity to misuse it. But again, that isn't clear in all of these cases. So they're all fact specific, and have to be looked at individually in that way, and it certainly cannot be assumed that the fears are all groundless. The other thing, looking at it generically, we would say in relation to why this case is a long way from the situation in the Media Mark case, where the data was recovered within 30 minutes, the time span for these cases is much greater than that. The court, I'm sure, is on top of the chronology, but just very briefly, the chronology is that in August 2019, the ABSs were sent to the wrong addresses. Not clear from the respondent's statement exactly when in August they were sent. And it's also not clear exactly when the respondent became aware of the error. But what is clear is the appellant started to become aware of the breach from September onwards on a variety of different dates, some of them before being told by the force in October. So there are a variety of different dates between September and October when they became aware of the breach. On the 24th of September, the respondent registered a potential breach with its monitoring tool. We see that from Mr. Green's statement. On or about the 4th of October, letters were written to the appellants by the force. We've seen examples of those, and you've seen that some of the appellants dispute receiving those. A minority of the appellants, fewer than 80, became aware in about October that their ABSs had been returned. Some discovered the statements for themselves, but the majority never became aware of what happened to their statements. So there's a variety of different factual circumstances, but all of them are a long way from the facts in the Media Mark case. Moving on from that, a point was taken that the appellants do not assert that the data in question included the fact that they were police officers. As a matter of fact, we say the ABS makes clear that the appellants were, or at the very least, had been police officers. To the extent that a pleading point is taken as to how we plead the data in question, we do not accept that the pleading does not encompass as part of the data the fact that the claimants were police officers. The particulars of claim refer to police service details as being part of the data in question. In any event, it's entirely clear from many of the schedules that the claimants regard the fact that the ABS revealed their status as a police officer as being a significant part of the factual matrix to them and the damage they claim. I should also say, before I leave pleading points, that the schedules are, of course, part of the pleaded case, and it isn't sufficient simply to look at the generic pleadings. One has to look at the entirety of the pleadings, including the schedule. Turning to the issue of whether there is a need for the respondent to have permission to appeal, we submit, for the reasons outlined yesterday by Lord Justice Warby, that there is. Pursuant to the judge's order, the claims were struck out on the basis that they did not disclose reasonable grounds for bringing the claim. We, of course, plead that the claimants did all suffer distress or an equivalent emotion, and for a strikeout application, the facts pleaded are assumed to be correct. What the respondent is now seeking, effectively, is summary judgment, which it didn't receive from the judge, nor did the judge strike out the claims as an abusive process. Therefore, the respondents are seeking a variation of the order made by the judge. So the question will be asked, well, what prejudice flows to the appellants from that if I'm right about it. The answer to that is certainly not that I wish to take an unattractive procedural point. But I do have concerns with the proposal now made by Mr. Charlotte, or made yesterday. This court should effectively determine the respondent's application for summary judgment of these claims, rather than simply reviewing the judge's decision. The Court of Appeal, of course, has wide powers. They're set out in Part CPR 5220. However, as I look at the rules, they don't in fact include determining an application, if to the extent that it's not been determined by the court below. And that, of course, would normally be the function of this court. But again, I want to stress, I'm not taking simply taking procedural points for the sake of it. If this court were determining this application afresh, the court would want to have before it all of the evidence that was put before the judge in relation to the summary judgment application. I know you've received a lot of material. The material before Mr. Justice Nicklin extended to some 10 or 12 lever arch files, and included, for example, witness statements in relation to some of the claimants that are not before this court. And I do question whether it is appropriate for this court to engage in an in-depth analysis of the individual claims and exactly what is said in them. Of course, I appreciate that's a matter for the court, ultimately, but again, it's my point in relation to the schedule handed up this morning as to whether that really is something the court can appropriately do. Just briefly on the question of delay, as part of Mr. Sharland's submissions that this court should now effectively determine his client's summary judgment application, he made a complaint about delay, both delayed by the appellants and delayed by the judge. As to delay by the appellants, the complaint that was made was that there was a delay between the 22nd of April 2021, when the claim was issued, to June the following year, when the particulars in the schedules were provided. Mr. Sharland's chronology, and I understand why, but it missed out much of the detail of what was happening during that 30 or 14-month period. The detail of procedurally what was happening in that period, if you're interested, and you may well not be, is in Mr. Hayes' fourth statement, which is in the supplemental bundle at page 196. But in summary, what was happening during that period was that the parties were liaising in relation to directions and seeking to agree common issues. And there was a debate at that stage as to what particulars should be provided in relation to each individual claimant, and the costs involved, and whether the response that we given to the respondent's RFI was adequate or not. It's not a case of nothing happening during that period. One or two other points in relation to, yes, there was much is made by the respondent about the absence of formal complaints being made contemporaneously. Why each claimant chose not to make a complaint would, I submit, have to be the subject of individual investigation. People can have all sorts of reasons for not making complaints, including, obviously, that they don't think making a complaint will make any difference. Of relevance here is that the respondent made its position that it wasn't going to pay compensation to the claimants clear to them pretty early, and well before the letter of action was written. But again, I submit it can't reasonably be said in relation to a claim of over 400 claimants that it follows from the fact that only a limited number of them made complaints that what they say about distress has no foundation. Connectedly, the respondent says there's no contemporaneous evidence that the appellants suffered distress. However, of course, we haven't got to the position yet of disclosure or the production of witness statements, and the appellants may well be able to call evidence from witnesses of the distress they suffered or point to contemporaneous evidence. We haven't got to that stage yet. Can I deal, I hope, briefly in relation to the threshold of seriousness and whether there is such a threshold. My friend submitted this morning that this court is bound by Lloyd and Google to find that there is a threshold, certainly as it regards the 98 Act. I'm not going to repeat my submissions yesterday, that was the Lord Legate's observations are based on a concession, and what he was referring to was a threshold of breach rather than a threshold of damage. But assuming you're against me in relation to that, it does beg the question as to what threshold we are talking about here. Is there a threshold of seriousness of breach? Is there a threshold of seriousness of damage? Are there two thresholds, one for damage and one for seriousness of breach? Or is there some kind of combination of the two which encompasses both aspects, which is all difficult, and it then begs the question as to wonder whether if there is a threshold, how high is it, and what should it be? A difficulty here is if there is a threshold involving both breach and damage, the court hasn't looked yet at the seriousness of the breach because that's not been investigated. It's not an issue. So it is only looking up, even though there is a threshold, at one half of the equation. All of which I suggest, first of all, is reasons why there shouldn't be a threshold, and the court should stick to the simple statutory test. But even if there is such a threshold, applying it to the facts of this case at a summary stage would be very difficult. My friend seeks to draw assistance from the existence of a threshold in the misuse tort. I took it yesterday to what Lord Legate said about that and the distinctions between the two torts. It's also important to point out that the misuse tort, of course, involves a balancing exercise, including in particular balancing between Article 8 and Article 10. That type of balancing exercise is not one that applies to claims under the Act. And where there is a balancing exercise, one can see the reason for having a threshold, which doesn't apply in relation to claims under the Act. My Lord Justice Warby pointed out this morning to recital 85 and the reference there to turn it up, significant economic or social, I think it says, disadvantage. We'll look at it.
Tab 4.
Yes, or any other significant economic or social disadvantage, and whether there's any argument that those words imply any form of threshold in relation to non-material damage, or indeed in relation to material damage. The word significant is that is separate from the example given in relation to loss of control. There's no suggestion that the loss of control needs to be significant. It's simply, the adjective is limited to economic or social disadvantage, and one can see why recovery for a trivial social disadvantage might be questionable. But I make my more fundamental point, which is if the legislature, either when passing the regulation or the Act itself, wished to put a threshold in, it would have done so and had every opportunity to do so, but has not. Briefly, in relation to the cases that my friend referred to this morning, Rolfe, the decision by Master MacLeod, my essential point in relation to these first instance decisions is that they are decisions on particular facts, which don't particularly assist in terms of points of principle. In relation to Rolfe, it's in particular important to note on the facts that there was no evidence from the claimants themselves as to the fact that they'd suffered distress, which was something that Master MacLeod considered was of particular importance in her assessment of the case.
On the law, she was bound by the Court of Appeal's decision in Lloyd and Google at the time, which held as referred to a concession, which the court seemed to think was right, or an agreement that there was a threshold. So she was working on a legal basis that was either right or wrong, depending on what we think about Lloyd and Google.
Yes,
In the
and what the concession was, but yes.
Yeah.
Yeah. What?
Anyway, she was working on the basis that the law, the data protection law, includes a threshold of seriousness.
Yes, and yes, and well, you have my position in relation to that. Driver, you've looked at, and obviously I heard my Lord Justice Warby's observation in relation to it, that if there was a threshold, then an award of £250 wouldn't cross it. Certainly, as you know, I'd submit there's no threshold. Whether the threshold is at a level that an award of £250 wouldn't cross it, I would question that, my lord. That brings me back to my point as to, well, if there is a threshold, where do you put it? If somebody's suffered distress, which entitles them to £250, obviously it's not a fortune, but in principle, that is an amount which is not de minimis, and there should be recovery for that sum. Instructive, perhaps in relation to that point, is the Johnson and Eastlight decision, which is referred to in Mr. Sharland's skeleton, where there was, you may recall, disclosure of a rent statement and very limited loss. But the master in that case still considered that although the loss was limited, there should in principle be recovery for small sums of damage. And he, or I should say, this is Master Thorne, took the view that there was a threshold. And he also taken the view that he was bound by Lloyd and Google and the Court of Appeal, but thought nevertheless it shouldn't be struck out because there should be recovery for modest sums. Briefly, in terms of the Advocate General in UI, on which reliance is placed, although there's an inconsistency between the Advocate General's opinion and the Court's opinion in that case, even what the Advocate General says is simply that mere upset is not recoverable. Plainly, he considers that distress would be recoverable. All he's excluding is mere upset or inconvenience, and that's not what the claimants claim here. On the 34 who assert not distress but something equivalent to it, again, those cases would have to be looked at individually. It's conceded that non-material damage might include something other than distress, and the example that was given by Mr. Sharland was that it would include serious psychiatric injury. In fact, a serious psychiatric injury would be material damage, not non-material damage. There's analysis of that by Lord Leggett in Lloyd. It's in paragraph 92. So a personal injury isn't in fact non-material damage. So that type of personal injury certainly cannot be what is meant by things other than distress coming within non-material damage. On the Jamil arguments, the spectre was pointed out by Mr. Sharland. While if these cases are allowed to continue, the court would face a trial in relation to liability, and then 400 odd cases all being sent out to the county court allocated to the small claims track, which is a familiar type of argument raised against claimants in group actions, but it is actually an unrealistic spectre as to what would happen in this case. What we are suggesting is trial of liability and a trial of a small number of test cases, in which the facts can be drilled down of those small number of test cases.
How would that work when, as I understand your submissions, all of this, you have lots of claimants who've asserted non-material damage of one sort or another. The point is made against you that it's nonsense. You say, oh, well, that's all a matter for the judge to decide. We need evidence on this. It might be credibility, it might be cogency, it might be anything. How could you avoid then having 400 small claims? This isn't going to be decided as a matter of principle. It all depends on the evidence. I thought that was your submission.
It is my submission. What I'm saying, my lady, is that as a matter of practicality in group actions or collective actions, sorry, of course this isn't a group action,
No.
collective actions, that isn't how they are case managed, even if there are individual issues in relation to causation and damage, as there often are. What happens in practice is that there is a trial of a certain number of the generic liability issues and a certain number of test cases.
Yes, because that's usually because there are points of principle, aren't there, that cut across. But here, as I've heard you, and maybe I've misunderstood, isn't everything we're saying, it all comes down to the evidence in the end. These are all credibility issues, ultimately. How can you decide that as a matter of lead case or test cases?
Because in practice, my lady, if the judge hears 10 test cases and he finds all of those 10 test cases, with say 5 being selected by the defendant, 5 being selected by the claimant, and he finds or she finds that they're all made up, although liability, of course, there's only a right that liability is established, but they're all incredible, and I don't believe any of these people have suffered any non-material damage. In practice, although of course that finding and recognition of credibility is not binding on relation to the other 400.
You could have 380 saying, well, we'd like to carry on because
But
we'll be better giving evidence. I mean, it may be how it doesn't normally. I mean, I have knocked around a bit, so I know it doesn't normally happen like that. But that's not really how we decide things here.
Well, look, of course I accept that there wouldn't be formally binding on them. But my lady's observation is, well, that's not how we normally decide things. Of course, I appreciate the court is applying strict legal principles. Obviously, I understand that. But in terms of looking at a Jamil argument as to proportionality and, well, can the court fashion a proportionate way of dealing with these cases? The court should, I submit, look at the reality of how a case of this nature could be tried. And the reality is that if the lead cases all fail, the remainder of the claimants would be will not continue, and no doubt if they did wish to continue, they'd be subject to warnings by the court who heard the 10 cases. And in reality, if the 10 succeed, the defendants will make settlement offers, because trying another selection of test cases in circumstances you've lost the first 10 would be a nonsense. So I appreciate, my lady's obviously right about formally not binding, but it's not right as a matter of practice as to how a proportionate way of managing these claims is achieved in practice. And if my lady were right, with respect, it would make the conduct of group actions, which are obviously often done by way of lead cases, very difficult.
Yeah, but you're slightly missing my point, if I may say so.
Well, I'm sorry if I am.
Which is, well, so am I. Which is that this, I haven't yet seen, because you haven't explained to us, what is the point that you're going to take as a test case? Because as I've understood your case, this is all about individuals' evidence about whether they were distressed, whether they suffered non-material damage, and they've got to establish that on evidence. And there may be, some of them are believed and some of them not believed. And I'm struggling to see at the moment how that could be short-circuited by test cases.
Well, it would be testing whether, at least in respect to those 10, they persuaded the court that their distress was real and entitlement to compensation. It would resolve the issues to, at least in respect to those 10, what they're entitled to, assuming they recover. So it would give a measure of likely recovery, which
would do that.
well, of course, one of the defendant's points is, well, even if they've suffered distress here, these cases are.
So it really comes, and maybe this is true of GLOs generally, or group actions, or whatever these are called, collective actions. Really, it comes to, you'll test out the evidence on, let's say, a sample of 10, which will be a spread across, to really test credibility, and that will put the parties in a better commercial position to know whether they should be buying off the rest of the claim, whether the respondent should buy off the rest of the claims or hold fast, or whether the rest of the claimants should drop their claims in light of that. That's really where we are. Is that right?
I would slightly correlate the use of the word buy off, but leave that to one side. But yes, my lady, that is essentially what I am saying. But that is common in group actions, and how is the court going to manage collective actions in respect of individual claimants who are all claiming small amounts of damage? My lady, I appreciate...
Because my experience of those, which probably isn't as much as yours, is that there are usually points of principle that cut across, and that's what you take on the test case. Credibility is not a point of principle, it's a piece by piece. So that's what strikes me as different about all of these claims, is that, I mean, there may be other nuts and bolts as well, but at the heart of them are credibility issues.
Yes, but bear in mind, of course, here, Mr. Sharland's submission is, well, it is entirely implausible and incredible that any of these people could have suffered the distress they claim. So it isn't simply a matter of assessment of their individual evidence. We're apart on that. But it is testing that issue as to whether there is a basis on which there could be a credible assertion of distress here. So, Melanie, I agree it does look at drilling down the individual facts, but if the court found against the claimants, well, all of these 10 claimants the evidence is incredible and they haven't in fact suffered any distress, or the distress they have suffered is caused by something else, whatever conclusions they make, that would have value to the resolution of the other 420.
Okay, thank you.
So really then your response to the Jamil point is that there is a proper and appropriate way that the cases could be managed proportionately.
Absolutely there is, and I repeat, well, I hesitate to repeat, but I submit, as I did yesterday, that it would be a very sad indictment of our judicial system if it were otherwise. Can I deal with one discrete point, which I suspect is not particularly important, but it's been raised by the Commissioner, so I ought at least deal with it, which is the point argued by the Commissioner that there's no distinction between remedies under Articles 82.1 and 82.2 in terms of compensation, and effectively being said that the entitlement to compensation only arises if there's been processing, not for infringement that doesn't involve processing. That is likely to be, as Mr. Knight said yesterday, academic, as there was processing in our case. And as he rightly said yesterday, our claim to damage as a result of an infringement that did not involve processing is a fallback position. However, all that said, and with respect to the Commissioner, we do stand by our submission, and with respect, wonder if the Commissioner is right about this. Can I take you briefly to the GDPR, which is at tab 4. and ask you to look at Article 34 on page 34. Which deals with the obligation to communicate a data breach in circumstances where the breach is likely to result in a high risk to the rights and freedoms of natural persons. Where there's data breach, there's an obligation to notify the data subjects of that. It is easy to see how a failure to comply with Article 34 might give rise to damage. You're not told about the existence of a breach. But it is difficult to see how communication of a breach falls within the definition of processing. So,
well, you're communicating, you're publishing to them information that they have been the subject of a data breach, which is personal data.
well, you're not communicating the data itself. You're
No, but the personal data in this communication is you, as an identifiable natural individual, have been the subject of a data breach. They may not even describe it, but that's information about the person. It's really hard to see what you can do to a data subject or about a data subject without processing their personal data.
Well, the other example I was going to go to, my lord, is Article 32, which involves security of processing and the steps that the technical and organisational measures that have to be taken in relation to that. Some of these undoubtedly do involve processing, such as encryption of personal data. 32(1)(d), at the top of page 34, as a requirement for regularly testing, assessing and evaluating the effectiveness of technical and organisational measures. Does that involve processing? Evaluating the effectiveness of your measures? I can see it might do depending on how you did it, but I question whether that's processing.
No, well, it may not, but it's just hard to see how that breach could possibly lead to a claim for compensation without some processing taking place that was objectionable because of the failure.
But if the breach arose because there hadn't been adequate testing, the regularity of it hadn't been tested adequately, that could give rise to a loss. If that was what the cause was of the...
Could be the cause, but then, I mean, it seems to me that invariably there would have to be some processing as an intermediate step between the failure, the infringement that you're looking at, and any material or non-material loss that would justify compensation. But I think, as we all probably agree, this is an academic point. And I'm
yes,
my own part,
it is.
I'm not sure that we should necessarily depart from the usual wise principle that we decide only the things we need to decide.
I think we've got enough to decide.
Yes, look, I'm not encouraging the court to decide things it doesn't need to.
I was just interested to discover, as we did, whether the Commissioner agreed with you on this. There is a disagreement. That may be as much as we need to know.
Yes, obviously it's not our primary point. But can I say this in my final submission, my lady, which is essentially what the respondent says here is these cases are absurd. There's no way that these 400 people could possibly have suffered distress. That is not, I suggest, something that can be determined on a summary basis, and it's not something that the court found. Mr. Justice Nicklin did not come to that conclusion, and certainly based on the 14 cases he did analyse, not something he felt was appropriate to do. And that is at the core of his appeal, certainly at the core of the respondent's notice issues. But unless I can assist you further.
No, thank you very much indeed. Well, can I thank you all very much indeed for all your submissions and all the hard work, not just on the front row, including the Commissioner on the front row for these purposes, but also the juniors and all the solicitors and people who have assisted in putting together the bundles and the information in this important and difficult case. You won't be surprised to hear that we're going to reserve our judgments. I'm not able to tell you at this stage when we will be handing them down, but obviously we will do that as soon as practical. They'll be sent out in the normal way in draft. Now, in this case, where there are over 400 appellants, the terms of the embargo are particularly important, and so only people who absolutely must see our drafts must have access to them in the normal way, and we need the information filing in the normal way, please. Any typographical or other minor errors and infelicities can be referred to us, but it's not an opportunity to re-argue the case, and we'll hand the matter down electronically. I would hope that any other matters can be dealt with on paper, and that ultimately you'll be able to agree an order. But if there's any residual outstanding matters, then we'll deal with them on paper. So unless there's anything else that we... Yes, there is.
No, I just wanted to ask for a clarification in terms of the embargo.
Yes,
you mentioned it. Of course, I understand the importance of it. Is the court's direction in relation to the embargo judgment that it should not be sent to the 400 appellants, or is it that it can be, but they have to be individually informed of the importance of the embargo?
Normal embargo is parties as well as the solicitors, so we need to make it.
Yes, I approved it. And solicitors. Yes, I think it's not. I think 400 people is too many.
I understand.
But I understand, of course, that we need to make an correction because the normal embargo is terms of allows to go to the parties.
Yes. What I don't know is whether there are one or two particular appellants who. From whom instructions are taken as effectively lead appellants.
Yes, certainly. Well, look.
If there are, can that be made clear to the court as to whether
of course
they can be included within the...
Of course. I perfectly understand that, and that's often the case, and that would be appropriate, but subject to you making strong submissions to the contrary, I think 400 is too many.
I understand.
But yes, certainly, but make sure the court is aware of who those lead litigants are.
Yes.
So that we have a complete list of who's going to have access to the material.
Yes.
And any observations to make about that, Mr. Charlotte?
No, my lady. I think it's very sensible. It's really a matter for the court. I don't think I need to trouble you.
Very well. Thank you all very much indeed.
What were I able to?